Hello and welcome to BYJU'S IAS. Welcome to Target Prelims 2021. Today is Lecture 2 of Polity-based Current Affairs for Prelims 2021. Today is also Teachers' Day, so happy Teachers' Day to me. Let's get started and look at question number 1. Consider the following statements. Number 1, to create a new ministry, a constitutional amendment under Article 368 is needed. Statement 2, the allocation of portfolios is the prerogative of the Prime Minister. Now, let me tell you something very important regarding this question. The year was 2011, 97th Constitutional Amendment Act was passed. Because of this constitutional amendment, what happened? Number 1, Part 9B was added to the Constitution, which deals with cooperatives. Also, Article 19(1)(c) was added, which gives a fundamental right to every single citizen of this country that you can form unions, associations, as well as cooperative societies. So forming a cooperative society is a fundamental right under Article 19. Also, Article 43(B) was added, which deals with directive principles of state policy, which says that the state shall endeavor. What the state will endeavor? That we will create these cooperatives so that on these cooperatives we have democratic control, so that these cooperatives are professionally managed. This was a directive principle added in the year 2011. Now, something else happened. Mr. Rajendra Shah, he approached the Gujarat High Court challenging the constitutional validity of the 97th Constitutional Amendment Act. And Gujarat High Court ruled in favor of Mr. Rajendra Shah. Then the central government filed an appeal before the Supreme Court. And this judgment was given in 2021. Union of India versus Rajendra Shah, 2021. In this case, what the Supreme Court said? Supreme Court said we don't have an issue with Article 19(1)(c), which is a fundamental right. So you might be asked about 97th Amendment in 2001. It made changes to which of the following things? Directive principles, fundamental rights. Another part was added to the Constitution. Supreme Court said we don't have a problem with this fundamental right. We don't have a problem with this directive principle of state policy as well. In fact, it was not even challenged. But we have a problem with adding Part 9(B) to the Constitution, which gives power to the central government that you can manage these cooperatives. The problem is, cooperatives comes under state list. Schedule 7 of the Constitution talks about distribution of legislative subjects into union list, state list, and concurrent list. In state list, cooperatives is mentioned. So if this constitutional amendment gives power to the central government that you can manage these cooperatives, it snatches the power of the state. And that is why Supreme Court in 2021 partially struck down this 97th Constitutional Amendment Act, saying, no, this is not how you should have done this. What you should have done, although you have enacted a Constitutional Amendment Act, you have amended the Constitution using Article 368, but in the process, it affects federal feature of the Constitution. And you would know that if any constitutional amendment affects, alters, or touches the federal features of the Constitution, you require not only special majority in the Constitution, in the Parliament, you also require ratification by more than half of the states. This is where it becomes interesting. Why? Because a new ministry has now been created, Ministry of Cooperation, which is headed by the Home Minister, Mr. Amit Shah. Mr. Amit Shah is also now the Minister for Cooperation of Cooperatives. What is the context? Constitutional Amendment Bill, how is it passed? And if this Constitutional Amendment Bill alters the federal features of our Constitution, which are these federal features? For that, you require ratification by more than half of the states as well. Let's recap. This is a constitutional amendment bill. this bill can be introduced in either Lok Sabha or Rajya Sabha. First in Lok Sabha, then in Rajya Sabha, or first in Rajya Sabha, then in Lok Sabha. It does not require previous sanction of the President of India. This constitutional amendment bill can be introduced by a minister or by a private member, doesn't matter. So this constitutional amendment bill can be introduced by a minister or a private member without previous consent of the President of India, can be introduced in either Lok Sabha or Rajya Sabha. And this constitutional amendment bill should be passed by both houses of the Indian Parliament separately. That means normally what happens when on a particular bill there is a deadlock. That means one house agrees with a bill, another house disagrees with a bill, rejects a bill, there is a deadlock. And to resolve that deadlock, we have a joint sitting of the two houses. But this joint sitting of two houses is not an option for a constitutional amendment bill. A constitutional amendment bill should be passed by both houses of the Parliament separately by special majority. But if this constitutional amendment bill alters the federal features of the Constitution, you require ratification by more than half of the states as well. Which are these federal features? Can be asked in your prelims examination. Number one, if you change the manner or the method of the election of the President of India, you need ratification by more than half of the states. If you change or alter the executive power of the Union, you require ratification by more than half of the states. If you alter the functioning or the mechanism related to the Supreme Court and High Courts in this country, you require ratification by more than half of the states as well. Also, if you change, alter Schedule 7 of the Constitution, you require ratification by more than half of the states. Also, if you change Schedule 4 of the Constitution, remember Schedule 4 talks about representation of states in Rajya Sabha. How many members from UP are there in Rajya Sabha? That's mentioned in the Schedule 4 of the Constitution. If you alter Schedule 4 of the Constitution, you need ratification by more than half of the states as well. But here remember, if Parliament passes a law under Article 2 and 3, if Parliament passes a law under Article 2 and 3, there will be change in Schedule 4. But this change is coincidental. This change is supplemental. For that, you don't need constitutional amendment. You don't need to take the help of Article 368 of the Constitution. Only if you are passing a law under Article 2 and 3. But without using Article 2 and 3, if you are changing, if you want to alter Schedule 4 of the Constitution, you require ratification by more than half of the states as well. Or if you change Article 368 itself, that also requires ratification by more than half of the states. Supreme Court said in Rajendra Shah case that since you have passed a constitutional amendment in 2011, it has altered the legislative subjects, the distribution of legislative subjects between the center and the state. It has altered Schedule 7 of the Constitution. You should have, apart from passing a constitutional amendment bill, you should also have got this bill ratified by more than half of the states as well. Since this is something that you didn't do, you didn't opt for, that's why this Part 9B of the Constitution, this Part 9B of the Constitution, which talks about cooperatives, insofar as it talks about center's power to control these cooperatives, it's unconstitutional. But Supreme Court only partially struck it down, not completely. Why? Supreme Court said if there are multi-state cooperative societies which are functional in different states, that power to control, to manage these multi-state cooperative societies, that power will be with the Parliament. But so far as cooperatives within a state is concerned, that is within the legitimate domain of the states. You cannot snatch the powers of the states. If you want to, you have to pass a constitutional amendment bill and get it ratified by more than half of the states as well. That's number one. Number two, a new ministry has been created, Ministry of Cooperation. Prior to that, this Ministry of Cooperation, it was a department. And it was a department under the Ministry of Agriculture and Farmers' Welfare. So you might be asked that prior to the creation of Ministry of Cooperation, was it a department? It was a department under the Ministry of Agriculture and Farmers' Welfare. What was the intention? The intention of the government was, let's have another ministry, Ministry of Cooperation. What is the purpose? The purpose is to streamline ease of doing business when it comes to these cooperative societies. To streamline, that's the objective number one. You may be asked about the objective for creating such a ministry as well. The objective is to streamline the functioning or to streamline the ease of doing business of these cooperatives. Also, the objective also is so as to ensure the development of these multi-state cooperative societies. That is how this Ministry of Cooperation was created. But in order to create a ministry, there is no need to amend the Constitution. There is no need to take the help of Article 368 of the Constitution. You just need to make changes to allocation of business rules 1961. So in order to create a new ministry, you don't need to amend the Constitution using Article 368. You just need to make changes to this rule, allocation of business rule 1961. Let's look at the question. To create a new ministry, a constitutional amendment under Article 368 is needed? No. The allocation of portfolios is the prerogative of the Prime Minister. This is correct. Which of the above statements is or are correct? B, only 2 is the right answer. There is no mention of Home Ministry, Defense Ministry, External Affairs Ministry in the Constitution. It is mentioned in the allocation of business rules 1961. Who gets which ministry? That's the prerogative of the Prime Minister. That means although a minister is appointed by the President, a minister is individually responsible to the President of India, but who gets which ministry? That's the prerogative of the Prime Minister. A minister can be appointed by the President only and only on the advice of the Prime Minister. Only 2, B, is the right answer. Let's look at another question on the same theme. The Supreme Court in 2021 completely struck down the 97th Constitutional Amendment Act that sought to provide a clear framework for the administration of cooperatives. This statement is incorrect. Why? Because not completely, I told you only partially. Partially in the sense, when it comes to multi-state cooperative societies, that's the power with the Parliament. When it comes to a cooperative society within a state, that's the prerogative of a state. Number 2, the Supreme Court has stated that cooperatives and any form of legislation pertaining to them are strictly within the domain of the state government and legislatures. That's correct. In matters related to multi-state cooperative societies, the Parliament has the power to legislate. Which of the above statements is or are correct? 2 and 3 are correct, which means C is the right answer. Let's look at another question. And recently, Punjab became the 20th state to implement Civil Services Board. Recently also, the Karnataka High Court pulled the state government of Karnataka. Why are you not implementing the Civil Services Board? This question has once been asked in your prelims examination, I guess in 2013. But now, let's look at this question again. The year was 2013. In TSR Subramaniam case, a former bureaucrat approached the Supreme Court, and the Supreme Court said bureaucrats need not take oral advice, oral directions from a minister. A bureaucrat has to take only a written directive, written advice, or written order from a particular minister. There was also this controversy that the politicians, the government of the day, they punish a particular bureaucrat. How? By transferring that bureaucrat from one department to another. So this transfer of a bureaucrat is considered to be some sort of punishment, and because of which a bureaucrat is not in a position to independently function what is required of him. That's why the Supreme Court ordered that every state should create a Civil Services Board. That means there has to be a Civil Services Board in every state. There has to be a Civil Services Board at the center as well. And there has to be a tenure for a bureaucrat. An IAS officer should have a tenure of 2 years. If you want to transfer this bureaucrat before completing the tenure of 2 years, what you need? You need the permission of the Civil Services Board. Statement number 1. Recommendations for transfers of IAS officers before the 2-year tenure will be examined by the board. That's correct. Punjab is the only state to not have a Civil Services Board. No. Punjab is the 20th state to implement Civil Services Board. There are others which have not implemented. The board is headed by the Chief Minister. No. At the central level, the board is headed by a cabinet secretary. At the state level, this board is headed by a chief secretary. That is why statement 3 is incorrect. The question is asking which of the above statements is or are correct. Only 1A is the right answer. Let's look at another question. Which of the following statements is incorrect regarding the 10th schedule of Indian Constitution, which deals with anti-defection law? Defections, Ayaram Gayaram, popular even now. Look at West Bengal. Some of the members of the Tribunal Congress, they switched over to the BJP, got elected, and now are going back to the Tribunal Congress. Sachin Pilot rebelled against the Chief Minister Ashok Gehlot. Ultimately, what happened? The Speaker of the Rajasthan Legislative Assembly issued a show cause notice to Sachin Pilot and some of his supporter MLAs, asking why action should not be taken against you under anti-defection law, why you should not be disqualified under the 10th schedule of the Indian Constitution. Sachin Pilot was represented by Mukul Rohatgi, represented by Harish Salve in the court. And the court said, there is no dissent, there is no provision for dissent in political parties. If there is a legislator who is expressing disagreement, who is expressing dissent against the party, against the members of the political party, does that mean expressing this dissent should render that legislator disqualified under anti-defection law? So anti-defection law is in the news because of what is happening in West Bengal, what happened in Rajasthan. So you might expect a question on anti-defection law. Let's briefly discuss what is this anti-defection law. What are these provisions? Number 1, the year was 1985 when 52nd Constitutional Amendment Act was passed, which added 10th schedule to the Constitution, which talks about anti-defection law. What are the provisions? Provision number 1, I am a member of a house. House can be either Lok Sabha or Rajya Sabha, Legislative Assembly or Legislative Council. If I am a member of a house, but I belong to a political party, Congress, BJP, Aam Aadmi Party, any political party, if I am a legislator belonging to a house, belonging to a particular political party, if I voluntarily resign from this party, I will be disqualified under anti-defection law. But very interesting thing here, Sachin Pilot had not resigned. Sachin Pilot had not voluntarily resigned from Congress party. Then why did the Speaker of the Legislative Assembly of Rajasthan issue a show cause notice to Sachin Pilot, asking him why you should not be disqualified under anti-defection law? Because Sachin Pilot had not resigned. The court in numerous judgments in the past, Keshav Prasad Maurya, other judgments, Supreme Court said voluntary resignation does not mean that a legislator has to submit a formal resignation to the party or a formal resignation to the presiding officer that I'm resigning from my political party. Formal resignation letter is not required. Then what is required? If the conduct of the legislator outside the house is such that we can safely assume that this legislator has voluntarily resigned from his party. Maybe he is not attending the meetings of the political party. Maybe he is campaigning against the members of his political party. Maybe he is attending the rallies of the opposition political party. Maybe he is attending the meetings of the opposition political party. So this gentleman, this legislator, he has not voluntarily resigned from his party, but his conduct outside the house is such that we can safely assume that this legislator has voluntarily resigned from his party. Even without a formal resignation letter, you can be disqualified under anti-defection law. That's provision number 1. Provision number 2, if you violate a whip issued by the political party, you will be disqualified. But please remember, there are 3 types of whips: 1-line whip, 2-line whip, 3-line whip. If you violate 1-line whip, 2-line whip, you won't come under the disqualification under anti-defection law. But if you violate 3-line whip, you will be disqualified under anti-defection law, but with one condition. 15-day period can be very, very important for this year's prelims examination. If I'm a legislator, I belong to a political party. The political party says you have to vote in favor of this bill, but I'm voting against this bill, which means I'm violating the whip, or I'm abstaining from voting, which means I'm violating the whip. Will I be disqualified? Yes, but 15 days are provided. If my political party condones my action, supports my action, saying no, he has violated our whip, but don't take action against this legislator, I am saved, I will not be disqualified under anti-defection law. If you violate a 3-line whip and your political party does not condone your action within 15 days, after the expiry of 15-day period, you will be disqualified under anti-defection law. Provision number 3, if an independent member, who is an independent member, I contested elections as an independent candidate, no political party gave me the ticket, I won the election, now I am a member of a house, which can be Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council. I am an independent member. I cannot join a political party. After my election, if I join a political party, disqualified under anti-defection law. And 4th important provision, for a nominated member. Who is a nominated member? A nominated member of Rajya Sabha, for example. A nominated member of Legislative Council, for example. This nominated member is provided with 6 months. Within 6 months of your nomination, you can join a political party. But if you join a political party because you're a nominated member of the House, if a nominated member of a House joins a political party after 6 months of nomination, disqualified under anti-defection law. These are very important provisions. And who gets to decide whether you should be disqualified or not? Speaker of Lok Sabha, Speaker of Legislative Assembly. Who gets to decide? Chairperson of Rajya Sabha, Chairperson of the Legislative Council. They get to decide, the presiding officers get to decide whether a particular member should be disqualified under anti-defection law. Clear? Let's look at the question. Which of the following statements is incorrect regarding the 10th schedule of the Indian Constitution? Number 1, the schedule was added in 1985 to disqualify a party member who voluntarily resigns from his political party after the elections. Let's wait here, let's look at other options and you will understand what is the answer. The schedule is silent regarding the legislators who are expelled by their political parties. If you look at the provisions, if you voluntarily resign, disqualified. If you violate the whip, you're disqualified. There is no provision in anti-defection law which talks about what if a legislator is expelled by the political party. What if a particular legislator is expelled by one political party, what will happen to him? In that case, there are numerous judgments of the courts. They will have to approach the court and sometimes the court declares them as independent member of the House. But 10th schedule is silent on what happens to a legislator who has been expelled by the political party. Third, the Speaker of the Lok Sabha is the final authority to decide on the disqualification petitions against the Lok Sabha MPs. This statement is also correct. Yes, there is a judicial review because judicial review is part of the basic structure of Indian Constitution, but final authority is the Speaker. After the Speaker takes a decision, this decision of the Speaker will be reviewed by the judiciary. And if the judiciary agrees, member is disqualified. If the judiciary does not agree, then the member is saved from disqualification. But the final authority is the Speaker, but Speaker's decision is subject to judicial review. But statement A is incorrect. Why incorrect? That's why you have to read the options carefully. 10th schedule, anti-defection law, only talks about a member of a house, only talks about a legislator. It does not talk about a party member. I am a party member. I belong to Congress or BJP, but I am not a member of a house. Whether I joined Congress or Aam Aadmi Party doesn't matter, because how will I be disqualified? 10th schedule talks about disqualification from a house. I am not a member of a house, so how can I be disqualified? That's why statement A is incorrect, because it says the schedule talks about to disqualify a party member who voluntarily resigns from his political party after the elections. It does not talk about a party member, it talks about a member of a house. It talks about a legislator. That's why statement A is incorrect. A is the right answer. Looks slightly tricky, but if you understand the concept, you would be in a position to mark it correctly. Let's look at another question. Which of the following statements is or are correct regarding anti-defection law? Number 1, only a legislator can file a disqualification petition before the presiding officer. Number 2, a legislator disqualified under the law is disallowed to contest elections for the remainder of the term. Statement 1 is incorrect. Why? 2013, in Speaker of Odisha Legislative Assembly versus Mr. Parida, the Supreme Court said, prior to that the rules were, if a legislator is to be disqualified, who can file a petition before the presiding officer that this person is subject to anti-defection law should be disqualified. Prior to 2013, the rule said a legislator should file a complaint. That means a legislator, a member of a house, should complain to the speaker that please disqualify this individual under anti-defection law. 2013, the Supreme Court said any voter, for that matter, any individual has locus standi. Anyone can approach the presiding officer and ask for the disqualification of a member under anti-defection law. So you don't have to be a legislator to file a petition. If you are a common man, an ordinary person, a voter, you have the locus standi, you have the power to approach the presiding officer for disqualifying an MP or a legislator under anti-defection law. So statement 1 is incorrect. A legislator disqualified under the law is disallowed to contest elections for the remainder of the term. This statement is also incorrect. The question is asking which of the following statements are correct. None of these statements are correct. D is the right answer. Something happened in Karnataka. Some 17 MLAs belonging to Congress and the GDS, they resigned and joined the BJP. The Speaker of Karnataka Legislative Assembly said they should be disqualified for the remainder of the term. That means if I am a Congress MLA, I was elected for 5 years. After 1 year, I am resigning from my party and I'm joining another political party. I should be disqualified? Yes. The Speaker said disqualify this individual for the remainder of the term, which was 4 years. Matter was challenged before the court, before the Supreme Court. Supreme Court said no. Disqualify them, okay. But they should be allowed to contest elections again. And if they are allowed to contest elections again, and if the will of the people say, we agree with your defection, we are still reposing our trust in you, then we have to bow down before the will of the people of this country, because this is democracy. So a disqualifying legislator, person who has been disqualified, he can still contest the election again and get himself or herself elected. You are not disqualified for the remainder of the term. Both these statements are incorrect. D is the right answer. Let's look at another question. Which of the following is incorrect regarding the members of the Parliament Local Area Development Scheme, or MPLADS? The question is asking which of the following is incorrect. Statement 1. It is a central government scheme under which only the elected MPs of Lok Sabha and Rajya Sabha can recommend development programs involving spending of rupees 5 crore every year in their respective constituencies. It is a central government scheme which is created, established and it is under the control of the Ministry of Statistics and Program Implementation of the Government of India. But MPLAD, not only an elected MP, even if you are a nominated MP, for you also there is an MPLAD scheme. If you are a member of Lok Sabha, you can recommend works to the tune of 5 crore rupees in any part of your constituency, Lok Sabha MP. If you're a Rajya Sabha MP, you can recommend works to the tune of 5 crore rupees in any part of your state from which you have been elected to Rajya Sabha. If you're a nominated member of Rajya Sabha, the scheme is still valid for you, and you can recommend works to the tune of 5 crore rupees in any part of this country, any part of this country. So this scheme is not only for elected, it is also for nominated MPs. So first statement is incorrect. A is the right answer because the question is asking which of the following is or are incorrect. Let's look at statement number 2. The government in 2020 decided not to operate MPLADS for the financial year 2020-21 and 2021-22 because of the COVID-19 pandemic, so that we can save these resources and we can use them for our fight against the COVID-19 pandemic. So this statement is correct. States have their version of the scheme but with varying amounts per MLA. States also have their own MPLAD schemes. In some states, the works can be recommended to the tune of 6 crore rupees. So it's not necessary that 5 crore is the value. It can be 6 crore as well. D, the National Commission to Review the Working of the Constitution and the Second Administrative Reforms Commission 2007 had recommended discontinuation of the scheme. This statement is also correct. Why? Because somewhere down the line, when MPLAD scheme is in operation and MP is recommending works to the tune of 5 crore rupees, what is he recommending? A bridge to be constructed, a school to be constructed, a road to be constructed, a medical facility to be constructed. All these are within the legitimate domain of panchayats. So panchayats' legitimate power is snatched by the legislators using this MPLAD scheme. That is why there have been many reports, many suggestions that MPLAD scheme, to strengthen the Panchayati Raj institutions in this country, MPLAD scheme should be abolished. So all these statements are correct. The question is asking which of the following statements is incorrect. A is the right answer. Let's look at another question. Which of the following statements is incorrect regarding the Special Marriage Act of 1954? What is the context? Some states such as Gujarat, Madhya Pradesh, Uttar Pradesh, they passed these laws popularly known as anti-love jihad laws or love jihad laws, which prevent forceful conversion. Conversion before marriage, conversion after marriage. There is a law, a secular law in India called Special Marriage Act 1954, which is the simple law, a single law, which deals with inter-caste and inter-religious marriages. So a couple belonging to two different faiths, they can marry each other without any need for conversion, without any need for one party to convert or change his or her religion, and that law is the Special Marriage Act 1954. But there are some challenges with this law. What are these challenges? Challenge number 1, notice period. What is this notice period? This was in the news recently. Allahabad High Court said there is no need to put out a notice at a prominent place when a couple wants to marry. But that was only Allahabad High Court. It's not applicable throughout the country. But what is the issue? A boy and a girl, if they want to marry, the boy is from Karnataka, the girl is from Gujarat. Special Marriage Act says the boy and the girl, they have to register this marriage in a place where at least one of the party resides, which means either Karnataka or Gujarat, or where at least one of the party is residing for the past 30 days. So that means you can go to Delhi, stay there for 30 days, you're residing in Delhi for 30 days, now you can register your marriage in Delhi as well. But then notice period is there. Notice period in the sense, once you are applying for marriage, once you apply for the registration of the marriage, a prominent notice will be displayed outside the court office. A prominent notice will be displayed at the court to which you belong, which comes under your jurisdiction. You are from Gujarat, so in a local court in Gujarat, a prominent notice will be displayed that this particular individual wants to get married under Special Marriage Act in a state such as Delhi, in a place such as Delhi. So if you have any objections, file these objections within 30 days. Some say that it amounts to bullying, it amounts to violating right to marry, which is a fundamental right under Article 21 of the Constitution. But be that as it may, let's look at the question. Which of the following statements is incorrect regarding the Special Marriage Act? A couple shall have to give notice to the marriage officer of the district in which at least one of the parties to the marriage has resided for a period of not less than 30 days. But this statement is correct. Statement number 3, there is no provision in the law for the restitution of conjugal rights. We'll discuss this, give me a moment. Statement 3, any marriage solemnized under this act shall be null and void if the respondent was impotent at the time of the marriage. If the respondent was impotent, the marriage can be dissolved. This statement is correct. This law deals with marriage as well as divorce. So if the name is Special Marriage Act, that doesn't mean it only talks about marriage. It talks about divorce as well. The question is asking which of the following statements are incorrect. B is the right answer. Because Special Marriage Act 1954 does talk about restitution of conjugal rights. And this was a question asked, I think, in your last prelims examination as well. How? Pandita Rakhmabai. She was a child when she was married to Dadaji Bikaji. She was married, but then they didn't live together. Then once the Dadaji Bikaji turned 19, he asked Pandita Rakhmabai to stay with him because you are legally wedded to each other. Pandita Rakhmabai approached the court. The court said you can't force a child, when she was a child when she was married, you can't force her to cohabit, to live together. Because what is this restitution of conjugal rights? Restore the conjugal rights. If one partner does not live with you, this person can approach the court and ask the court to force this partner to live with him or her. That's what we call the restitution of conjugal rights. Pandita Rakhmabai won that case, but then she was also criticized. Some people said it's because of your education that you are now talking about these things, otherwise this is part of our culture. In fact, Bal Gangadhar Tilak also criticized Pandita Rakhmabai, saying that it's because of her education that she is in a position to file such a case. But the High Court overturned, and if she would violate this directive of the court, which means if she would not cohabit, live together with Dadaji Bikaji, her property could be confiscated. There was a lot of hue and cry at that time, way back in 1880s. Ultimately what happened? Dadaji Bikaji sought 2,000 rupees from Pandita Rakhmabai, and in exchange of 2,000 rupees, Dadaji Bikaji decided not to pursue this case. Pandita Rakhmabai went to London, and she became one of the first, I think, girl student to study medicine in London. So that was the landmark case dealing with restitution of conjugal rights. But this Special Marriage Act does talk about, has a provision for restitution of conjugal rights. B is incorrect. B is the right answer. Clear? Let's look at another question. Which of the following is incorrect regarding sedition law in India? Sedition law, you would know, has been in the news for a long time now. Sedition, which comes under Section 124 capital A of Indian Penal Code. If you are promoting disaffection, if you are inciting disaffection, not against the nation, but against the government established by law, you are guilty of sedition. So if somebody who is not promoting disaffection, but he is trying to incite disaffection against the government established by law, this is sedition. And IPC 124 capital A, it criminalizes attempts to incite disaffection against the government established by law. So this statement is correct, but the question is asking which of the following is incorrect. Statement 2, it is one of the reasonable restrictions on freedom of speech and expression under Article 19 Clause 2 of the Constitution. Article 19(1)(a), it talks about freedom of speech and expression. But this freedom of speech and expression is not an absolute fundamental right. It comes under reasonable restrictions. And there are 8 reasonable restrictions imposed on your freedom of speech and expression under Article 19, Clause 2 of the Constitution. Which are these 8 reasonable restrictions? Can be asked in your prelims exam. One is sovereignty and integrity of the nation, security of the state, friendly relations with foreign countries, public order, morality or decency, incitement to an offense, defamation. There are 8 reasonable restrictions on your freedom of speech and expression. Criminal contempt of court. Contempt of court is also a reasonable restriction under Article 19, Clause 2. Sedition is not one of these restrictions. In fact, the draft constitution talked about sedition as a reasonable restriction on your freedom of speech and expression, but ultimately it was dropped from the list of reasonable restrictions. Sedition entered through backdoor. Backdoor because of 1962 judgment, Kedarnath Singh. In 1962, Supreme Court upheld the validity of Section 124 capital A of Indian Penal Code. That means sedition originally was not a reasonable restriction on your freedom of speech and expression. It entered through a back door, through the judiciary, when it was given a constitutional, when it was declared constitutional in 1962. But it is not a reasonable restriction under Article 19, Clause 2. The question is asking which of the following is incorrect. B is incorrect. If you look at the conviction rate under sedition, the conviction rate is less than 3%. So this statement is also correct. Cases have been filed, but a majority of these cases are thrown by the judiciary. Majority, more than 97% of the times, is this section 124 capital A leads to acquittal. It does not lead to conviction. Which of the following is incorrect? B is the right answer. Let's look at another question. Consider the following statements. Right to protest is a fundamental right. Number 2, public places cannot be blocked by the people under any circumstance while expressing dissent over a governmental policy. Recently, Delhi High Court, I think yesterday Delhi High Court said the same thing. Right to protest is a fundamental right. Why? Number 1, you have Article 19(1)(a), which talks about freedom of speech and expression. At the same time, you have Article 19(1)(b), which talks about a right to assemble peacefully without arms. Right to assemble peacefully at a public place without arms is a fundamental right. That's why the court has said right to protest is also a fundamental right. But then something happened in Shaheen Bagh. The judgment was given by the court in 2020. People were protesting against the Citizenship Amendment Act of 2019. Protesters, particularly women, they started protesting at Shaheen Bagh and they blocked public places. When they blocked public places, it led to inconvenience as well. Matter went to the court. The Supreme Court gave a verdict after many, many months. After the protests at Shaheen Bagh were over because of the COVID-19 pandemic, after that the Supreme Court gave the order. Supreme Court said, yes, you have the right to protest, but you cannot block a public place indefinitely. If you want to protest, you have to protest at a designated area. So the Supreme Court said, yes, you have the right to protest, but for that you can't be blocking public property. You can't be blocking roads. You can't be inconveniencing the larger public because they have the freedom of movement as well. So if you want to protest, protest at a designated place. There you can protest. You can't block the public road. Many people criticize this verdict, but that's the relevant for your mains examination. For prelims examination, the Supreme Court said you can block a public place if the protest is spontaneous. Very important statement. blocking a public road, if it is spontaneous, it's okay. But the spontaneous protest, which leads to blocking of a public road, it cannot be for an indefinite period because it will lead to causing inconvenience to the public. That is why you can block a road but not for an indefinite period. That's what Supreme Court said in Shaheen Bagh case. And the same judgment was cited in farmers' protests as well. Farmers are also protesting even now as well against the 3 farm laws passed by the parliament last year. Matter went to the court. The court was asked by the petitioners that these farmers, they are causing inconvenience, they are blocking the roads. So you have given a verdict in Shaheen Bagh case that you cannot block a public property for an indefinite period. Please evict these farmers. The Supreme Court said no, right to protest is a fundamental right. Let them protest, we will not evict them. But the judgment still remains valid, which is you can block a public place if the protests are spontaneous but not for an indefinite period. Statement number 1. Consider the following statements. Which of the above statements are correct? Right to protest is a fundamental right. Correct. Public places cannot be blocked by the people under any circumstance while expressing dissent over a government policy. This is wrong. If the protest is spontaneous, it may lead to blocking of a public road, but not for an indefinite period. So this statement, this phrase, under any circumstance, renders statement 2 as incorrect. Which of the statements are correct? A, only 1 is the right answer. Understood? Let's look at something else. Mirror order. So you might be asked, mirror order is in the news recently. Which are these conditions under which this particular topic was in the news? Woman, she was from India. Man from Kenya. A couple, and they had a child. This child was under the custody of the woman. Now this child was to be transported or relocated to Kenya in another jurisdiction. In this case, what the court did, court imposed certain conditions. Certain conditions were imposed by the court dealing with how do you take care of the child because child is a minor, what are the conditions that you have to keep in mind. But this child was under the Indian jurisdiction. Now this child is going to travel to Kenya. Indian laws, Indian courts, Indian verdicts are not applicable in Kenya. In that case, what happens? The court in Kenya was asked for a mirror order. Mirror order. Same conditions imposed by the Indian court, same conditions are imposed by the Kenyan court as well. Identical conditions. Mirror order. That means the order issued by an Indian court, the same order is sought from a Kenyan court, mirror order, so that we are saving the dignity of a child, so that we are maintaining the rights of this child who is now going from one jurisdiction to another jurisdiction. Because the Indian judgment, the courts of India, they have no jurisdiction over citizens in Kenya. That is how in such cases mirror order is obtained. Mirror order will have the same conditions as imposed by an Indian court, same conditions will be imposed by the Kenyan court as well. So mirror order, recently seen in the news, related to the transportation or the relocation of a child from India to Kenya or from one jurisdiction to another jurisdiction. Let's look at the question. National Capital Territory. Government of National Capital Territory of Delhi Act was passed in 2021. This act basically said the term government in Delhi, in the Union Territory of Delhi, means Lieutenant Governor. This was highly controversial law passed by the Parliament this year, can be a potential question for your prelims examination. Consider the following statements regarding the Government of NCT Delhi Amendment Act 2021. Number 1, The Act bars the Delhi Legislative Assembly from making rules to regulate the procedure and conduct of business in the Assembly. Number 2, the Act requires the Lieutenant Governor to reserve all bills passed by the Assembly for the consideration of the President. Which of the above statements is or are correct? Statement number 1. The Act does not bar the Delhi Legislative Assembly from making its own rules. But the Act only says that these rules should be based on Lok Sabha rules. The Delhi Legislative Assembly can make rules, but these rules should be in agreement with the Lok Sabha rules. They cannot violate the Lok Sabha rules, the rules that we follow in Lok Sabha. So statement number 1 is incorrect because this Act does not bar Delhi Legislative Assembly from making rules. It can make rules, but these rules should be in agreement with the rules of the Lok Sabha, rules of business and procedure of Lok Sabha. Statement 2, the Act requires Lieutenant Governor to reserve all bills passed by the Legislative Assembly for the consideration of the President. No, both these statements are incorrect. None of these statements are correct. D is the right answer. This Act says that there are some bills which the Delhi Legislative Assembly's Lieutenant Governor will have to reserve for the President. For example, if the bill threatens the power of the High Court of Delhi, or if this bill is incidentally encroaching into the domain of center. Delhi is a union territory, but Delhi also has a chief minister, a democratically elected chief minister. Delhi also has a legislative assembly, but Legislative Assembly of Delhi cannot make laws on law and order, on police, on land. If the Delhi Legislative Assembly passes a bill on these subjects, such bills should be reserved for the consideration of the President. But if it passes another bill, any bill, but this bill incidentally deals with any of these subjects, such a bill also can be reserved for the consideration of the President. What is the issue here? School education, for example, it comes under the domain of the Legislative Assembly of Delhi. They have the power to make a law because education is in the concurrent list. But to create a school, establish a school, you may also need land. So you want to establish a school, for that you need a land, but land is under the union list. Land is under the control of the center when it comes to Delhi. So this bill of Delhi Legislative Assembly, which is basically talking about school, but incidentally it deals with land, which is under the domain of the center, such a bill also has to be reserved for the consideration of the President by the Lieutenant Governor. Not all bills, those bills which are under the domain of the center, or those which are incidentally under the domain of the center, not all bills. That's why both these statements are incorrect. The question is asking which of the above statements is or are correct. None of these statements are correct. D is the right answer. Let's look at another question. There have been frequent name changes. Some cities have been changed, their names have been changed. To change the name of a city, that's the job of a state. But when it comes to changing the name of a state, that is the power available with Parliament of India under Article 3 of the Constitution. Under Article 3, which some people say, which constitutional experts say, that Article 3 is one of the centralizing features of Indian federalism. Although we say India is a federal constitution, but there are some provisions in the Indian constitution which are biased in favor of a strong center, which give more power to the center as against the states. And one such provision, which is a centralizing bias, which acts as a centralizing bias in Indian federalism, is Article 3 of the Constitution. Under Article 3, the power is with the Parliament. That what Parliament can do? Parliament can change the name of a state. Parliament can divide a state. Parliament can bifurcate a state. Parliament can merge two or more states. Parliament can increase the area of a state, decrease the area of a state, alter the boundaries of the state. All these are powers available with Parliament under Article 3 of the Constitution. Interesting thing here is, whenever a bill, very important point, whenever a bill is to be introduced in the Parliament under Article 3 of the Constitution, this bill should be passed by simple majority. But such a bill can be introduced in the Parliament after the consent of the President. And before President can give his consent to the government that you can introduce this bill in the Parliament, President refers this bill to the State Legislative Assembly, which is going to be affected by this bill. For example, you want to change the name of West Bengal. For that, a bill has to be introduced in the Parliament. Parliament will pass this bill. Both houses of the Parliament will pass this bill, that too by simple majority. Then President will sign on this bill and the bill becomes an act. The change in name will take place for West Bengal. But President's consent is required. Where? When the government wants to introduce this bill in the Parliament, you have to first take the prior consent of the President of India. But President will not give the consent like that. President will have to refer this bill to the West Bengal Legislative Assembly, because West Bengal Legislative Assembly is going to be affected by this bill. The state is going to be affected by this bill. And the West Bengal Legislative Assembly will be asked by the President for its views. If the views are given, whatever views are given, this is not binding on the President of India, which may mean, for example, when Andhra Pradesh was bifurcated into Andhra Pradesh and Telangana, this bill was passed by the Parliament under Article 3. But before this bill could be passed, this bill was referred to the President of India asking for his prior consent. President, before giving his consent, referred this bill in a special plane to the Legislative Assembly of Andhra Pradesh. Andhra Pradesh Legislative Assembly passed a resolution rejecting the bifurcation of Andhra Pradesh. President said, doesn't matter, I'm going to give the consent to the government, please introduce this bill, get the bill passed. Andhra Pradesh was bifurcated into Andhra Pradesh and Telangana. That means there's a resolution passed by the Legislative Assembly which is going to be affected by this bill. This resolution is not binding on the President of India. Article 3 is in the news. The question was not asked last year, but maybe the question will be asked this year. If the paper, the prelims paper, is dominated by current affairs, these lectures are going to be immensely fruitful for you. But we don't know. UPSC, Unpredictable Service Commission, UPSC may ask only about the static part, only about the static content. So we can't prejudge what UPSC is going to do. But to be safer, you'll have to prepare for both static portions as well as current affairs as well. Static portion you would have covered. For current affairs, please rely on us. Hopefully, whatever we teach will be asked in the examination. Hope is a big thing here. Clear? So if Article 3 question was not asked last year, maybe it will be asked this year. Let's look at another question. Arrange the following states in the chronological order based on their creation as states of India. Why? Look at what happened between Assam and Mizoram. The security forces, the uniformed people of one state, killed the uniformed people of another state. At least 6 Assam police force personnel were killed, were martyred by the security forces of Mizoram police. So this was something rare, unheard of, or at least not heard for a long time in India, where the security forces of one state are killing the security forces of another state. If you look at the entire Northeast, Tripura was a union territory in 1956 when States Reorganization Act was passed. Manipur was also a union territory. Apart from that, whatever is there in Northeast was part of Assam. In fact, what is now known as Arunachal Pradesh, that was known as Northeastern Frontier Agency. And from 1951, it was directly controlled by the External Affairs Ministry of the Government of India. It was one district in Assam. Then Assam was reorganized. Nagaland was carved out from Assam. Mizoram was carved out from Assam. Arunachal Pradesh was carved out from Assam. So Assam is considered to be a big brother in Northeast. And there were these skirmishes, tensions between Mizoram and Assam, also tensions in Nagaland. That is why this question is asked in this time. Arrange the following states in the chronological order based on their creation as states. Nagaland was created in 1963. Meghalaya was created in 1972. Mizoram was initially created as a union territory, but it was given a statehood in the year 1987. The question is asking creation as states, not as union territories. As state, Mizoram was created in 1987. Sikkim, initially it was an associate state in 1974, but it became a full-fledged state in 1975. So if we have to arrange them in chronological order, Nagaland would be 1, Meghalaya would be 2, Sikkim would be 3, Mizoram would be 4. So 1, 2, 4, 3. A is the right answer. Let me check it again. Nagaland first, then Meghalaya, then Sikkim, then Mizoram. Absolutely correct. A, 1, 2, 4, 3 is the right answer. Let's look at another question. National Population Register. Citizenship Amendment Act was passed, but the rules have not been made to implement Citizenship Amendment Act. The government has sought more time has been given. Census exercise was also delayed. National Population Register exercise was also delayed because of COVID-19 pandemic. National Population Register is basically a register which contains details of all the usual residents of India. Now, who is a usual resident? Usual resident can be a citizen, can be an alien as well, can be a foreigner as well. Whoever is staying in India for 182 days or who wants to stay in India for 182 days, that particular individual becomes a usual resident. That means a usual resident can be a citizen, can be a foreigner as well. And National Population Register contains the details of all the usual residents of India. The National Population Register is a register of only the citizens of the country. This statement is wrong because it talks about usual residents. It is mandatory for every citizen of India to register in the NPR. This is absolutely correct. In NPR, you don't have to give any proof. Employees, the government employees, the survey people will come knocking at your door, will ask you certain questions about what is your Aadhaar, where were you staying, are you going to stay here for 6 or more months, name, so on and so forth, biometric information, demographic information. No proof is to be submitted, but these details will be sought. Clear? And it is mandatory for everybody to register in NPR. The database would contain demographic as well as biometric particulars. This is correct. The data for NPR was first collected in 1951. This is wrong. The question is asking which of the above statements is or are correct. 2 and 3 is correct. C is the right answer. National Population Register was first enacted or created or details were given in the year 2010. Then it was updated in the year 2015 when UPA was in power, and then it was sought to be updated in 2020 as well. But the form which was prepared by the central government regarding NPR, it generated a lot of controversy because for the first time, details such as Aadhaar were sought, details such as place of birth, details such as date of birth were sought. Although you don't have to submit the proof of it, but these questions were part of this NPR form. That is why it led to the controversy. That is why states such as Bihar, West Bengal, Kerala, Andhra Pradesh, they said that we are not going to implement NPR in the form it is presented today. We may update NPR based on 2015 criteria, 2010 criteria, but not on 2020 criteria because it was somewhere linked to the NRC or National Register of Citizens. Let's not get into that right now. So if NPR was first done in 2010, it was updated in 2015, it was sought to be updated in 2020 but was postponed because of the COVID-19 pandemic. So statement 2 and 3 are correct. C is the right answer. Now let's look at another question, and the context is still the same. The crisis that we witnessed in the Northeast, the skirmishes between Assam and Mizoram. Many sections of the society felt that if zonal councils were effectively working, then we won't be witnessing the crisis that we witnessed on the border between Assam and Mizoram. Zonal councils which were created to ensure that we have specialized forum where we can discuss all the problems with respect to that zone in absence of a very strong zonal council. Zonal councils are present, but some critics say because they are not effectively working, that's what led to this crisis. And zonal councils should be effectively working and we will solve the problem, the crisis in Northeast. That's why zonal councils can be asked in your prelims examination. There are 6 zonal councils. Northern Zonal Council, Southern, Eastern, Western and Central. These are 5 zonal councils. And we have another Northeastern Zonal Council. These 5 zonal councils, Northern, Southern, Eastern, Western and Central, they were created based on States Reorganization Act in 1956. But a 6th zonal council, Northeastern Zonal Council, it was created in 1971 based on Northeastern Zonal Council Act. So statement number 1, all the 6 zonal councils are statutory bodies. They are statutory bodies 100%, but they are created under the States Reorganization Act 1956. This is wrong. Why? Because not all have been created under States Reorganization Act. Northeastern Zonal Council was created based on, in pursuant of Northeastern Zonal Council Act 1971. So statement 1 is incorrect. The Prime Minister is the chairman of all zonal councils. No, it is the Union Home Minister who is the chairperson of all these zonal councils, all zonal councils. Union territories are not represented in the zonal councils. No, union territories are also represented in zonal councils. That's a very important statement for your prelims. Which of the above statements is or are correct? D. None of these statements are correct. D is the right answer. Let's look at another topic, criminalization of politics. What is this criminalization of politics? Matter went to the court that there are people, candidates with criminal past, and they are contesting elections. And the problem is, these lawbreakers, they become lawmakers. That is how somewhere down the line we have to stop criminalization of politics. Supreme Court, what it said all these candidates, and listen to me carefully, all these candidates with criminal past if these candidates are set up by the political parties have to provide the reason, why they gave ticket to these candidates with the criminal past. Why? Because citizens have the right to know. And this right to know is a fundamental right under Article 19 of the Constitution. So Supreme Court has basically said in Association for Democratic Reforms, ADR case, that citizens have the right to know the antecedents of a candidate. Citizens should know how many criminal cases are pending against a candidate. What is your educational qualification? What is the amount of assets in your name and in the name of your spouse? So that if voters have this information, based on this information, they can make an informed choice. So voters have the right to know the antecedents of the candidates set up by the political parties in these elections. Clear? And if political parties are giving tickets to candidates with criminal past, voters have the right to know why these political parties are giving tickets to these candidates with the criminal past, but don't tell us that they are winnable. Which means when political party will have to tell the voters, will have to tell the courts why we gave tickets to these candidates with criminal past. Political parties should not say because they are winnable, because they have the potential to win the election. That is why we have given them the tickets. Court said, no, don't give this reason. Give the real reason why you are giving tickets to these political parties, to these candidates with a criminal past. And at the same time, publish this reason on your website as well. Publish this reason why you gave tickets to criminals or candidates with a criminal past in 2 newspapers as well. Elections happened in Bihar. Majority of the political parties violated this Supreme Court order. How? Some parties, they did not disclose why we are giving tickets to candidates with a criminal past. Some blatantly refused. For example, Communist Party of India, Marxist, CPIM, Nationalist Congress Party, NCP. They blatantly refused. They didn't even give any reason why they are giving tickets to candidates with a criminal past. Some political parties gave the reason, but the same reason, winnable. These candidates had the potential to win. That is why we gave the tickets to them, despite the fact that the court had said, don't give us this reason, give us the real reason. Don't say that since these candidates are winnable, they can win the election, that's why you are giving tickets to them. Some political parties, they wrote the reason why they are giving tickets to these candidates with a criminal past, but at a distant place in a website where you can't reach. Some reasons were given in newspapers, but in those newspapers which hardly anybody reads. That means the Supreme Court order was blatantly violated. Then, contempt of court. Petition was filed against these political parties before the court. The court imposed fine on almost all these political parties for blatantly violating the Supreme Court order. Supreme Court had also said, whenever you give ticket to a candidate with a criminal past, within 48 hours, explain the reason. So if I am a candidate with a criminal past, I have been given ticket by a political party, within 48 hours of me getting the ticket, explain to the people why I was given the ticket despite the fact that I have a criminal past. Or not less than, it's a very important statement, not less than 2 weeks from the first date of filing nomination papers. This was something which was ordered by the Supreme Court. Supreme Court this year imposed a fine on all these political parties, asking them, fining them because they violated the Supreme Court order. But these political parties requested the Supreme Court that please don't force us to explain the reason 2 weeks before the first date of filing nomination papers. Court asked why. Political party said, sir, sometimes we give tickets to candidates after the nomination after the first day of the nomination papers. That means first day of nomination papers is today. After a few days, we give ticket to a candidate. So it is not possible for us to abide by your order because 2 weeks before the first day of the nomination papers filing, we cannot give you this information because maybe we have not set up a candidate. Because the court had said whichever is earlier. Whatever is earlier, 48 hours or 2 weeks, whichever is earlier, give us this information. Court said, okay, now this is not required. Not less than 2 weeks from the first date of the filing of the nomination papers. But whenever you give ticket to a candidate with a criminal past, within 48 hours, you have to explain the reason why you gave them tickets, but don't tell us Because they have winnable factor, because they have the potential to win the election. Give us the reason. And on website, at a prominent place, you have to explain the reason, because citizens have the right to know, and this right to know is a fundamental right under Article 19 of the Constitution. Since the contempt of court petition was filed against political parties were fined by the court as well, becomes a potential question for your prelims 2021. Let's look at another question, inner line permit. Again, because of what happened between Assam and Mizoram, because of the crisis that we see in Northeast. Few facts that you need to know. Inner line permit, where is it present? It's present in Arunachal Pradesh. It's present in Nagaland. It's present in Mizoram. And now it's also present in Manipur, which was a long pending demand of the people of Manipur that we should have an inner line permit. This permit, another important fact, is issued by the state governments. So state governments of Assam, Arunachal, Mizoram and Manipur, they issue permit. Permit, if you want to enter, if you want to stay in these areas, you have to approach the state governments. State governments will issue you a permit. Without this inner line permit, you cannot enter these areas. That is what inner line permit is. And the origin of this inner line permit goes back to Bengal Eastern Frontier Regulation Act of 1873. The intention of the British government was to regulate, to control the entry of non-tribals into the tribal areas of the Northeast. That is why inner line permit was imposed. And this is imposed based on this BEFR of 1873. These are the states where we have inner line permit. Important thing is this inner line permit is issued by the state governments. Is this constitutional? Why? Because we have something called Article 19(1)(d), Article 19(1)(e) of the Constitution, which talks about the fundamental right of every single citizen of this country. Because Article 19 is exclusively available to the citizens of India. Under Article 19, every single citizen of this country, he or she has a fundamental right to travel freely throughout the territory of India. That's what we call the freedom of movement, as well as freedom to reside and settle anywhere in the country. So freedom of movement is a fundamental right. Freedom to reside and settle anywhere in the country is a fundamental right. So isn't this inner line permit then violation of fundamental rights? No. Why? Because these two fundamental rights are not absolute. They come under reasonable restrictions. And there are two reasonable restrictions imposed. This can be potential question for your prelims. Reasonable restriction number 1, in the interests of the general public. Reason or reasonable restriction number 2, in the interests of the scheduled tribes. Since these are the tribal areas, in the interest of the tribal people, there can be restrictions on your freedom of movement. There can be restriction on your freedom to reside and settle anywhere within the territory of India. So inner line permit as a concept is not unconstitutional. This is something that can be important for prelims 2021. Let's look at something else. Staying with the Northeast, Arunachal Pradesh is demanding admission into the 6th schedule of the Constitution. What does that mean? There are tribal areas in states such as Assam, Meghalaya, Mizoram, and Tripura. The tribal areas of Assam, Meghalaya, Mizoram, and Tripura, they have some sort of special protection under Schedule 6 of the Constitution. But listen to me carefully. That does not mean that entire Assam is under 6th schedule, or entire Tripura, Mizoram, Meghalaya is under 6th schedule. There are 3 districts in Assam, 3 districts in Meghalaya, for example, Garo, Khasi, Jaintia, 3 in Mizoram, and 1 in Tripura. There are total 10 districts in India, in these 4 states, which are under protection under the 6th schedule. What sort of protection? The protection is that these 10 districts are to be administered as autonomous districts. And these autonomous districts will have district council. And this district council is a democratically elected body. 26 members are elected, 4 members are nominated by the governor, and Schedule 6, it not only protects the economic interest of the tribals in these 4 states, but also protects their culture, also protects their custom, also protects their religion, also protects their own judicial things. They can have their own laws related to land, they can impose their own taxes, they can have their own tolls, they can have their district council as well, in a sense, village courts as well. That means they will implement their own laws related to marriage, related to divorce, related to inheritance, related to adoption. That sort of autonomy is provided to these tribal districts, which are to be administered as autonomous districts under 6th schedule of the Constitution. Important thing is, President and the governor. Laws can be passed by Legislative Assembly. Laws can be passed by Parliament as well. Whether this parliamentary law will apply to these autonomous districts, that President will determine. Whether these Legislative Assembly laws will apply to these autonomous districts or will apply with some modifications, that governor will decide. But when it comes to Assam, the governor of Assam gets to decide whether a parliamentary law will apply to these autonomous districts, whether a state legislative law will apply to these autonomous districts or will apply with some modifications, that governor of Assam will decide. So governor of Assam will decide whether a parliamentary law or a state law will apply to the autonomous districts of Assam. But so far as other 3 states are concerned, governor will decide when it comes to the law passed by the state legislature. President will get to decide when it comes to the law passed by the parliament. That is why some sort of autonomy is provided to these tribal districts. And Arunachal Pradesh is now asking, we also need protection under 6th schedule of the Constitution. Ladakh Union Territory is also asking that we need protection under 6th schedule of the Constitution. And in fact, there is a constitutional amendment bill pending in the parliament which talks about giving more powers to these autonomous districts. All these things put together make 6th schedule of the Constitution very important for your prelims 2021. So this is related to 6th schedule of the Constitution. Done? Let's look at another question. Which of the following statements is or are correct? Number 1, in order to save the time of the court, the consent of the Attorney General is required before initiating a criminal contempt of court case against an individual. No court shall initiate any proceedings of contempt after the expiry of a period of 1 year from the date on which the contempt is alleged to have been committed. Select the correct options from below. Prashant Bhushan was convicted for contempt. ₹1 fine was imposed on him. There is another case on Prashant Bhushan, contempt of court case, which is pending right now in the court. This case deals with the interview given by Prashant Bhushan to Tehelka magazine in 2009. In that interview, he said, half of the previous 16 chief justices were corrupt. That's what Prashant Bhushan, advocate, activist, who is a prominent public interest litigation activist in India, he gave an interview in 2009 to Tehelka magazine saying at least half of the previous 16 chief justices were corrupt. The case is of 2009. It is pending today. Does that mean statement 2 is correct or incorrect? Let's discuss this. Contempt of court is in the news. Attorney General was given extension in his tenure. So Attorney General is in the news. Contempt of court is in the news. This can be potential question for your prelims. Number 1. When it comes to contempt of court is both a civil offense as well as a criminal offense. So this is something that you should have a clarity. It's both a civil offense as well as a criminal offense. Civil offense means willful disobedience of a court order. So the court is asking me, this is the place belonging to someone else, you are illegally occupying this place, vacate this place. If I say no, if I refuse, that means I am willfully disobeying a court order, but this is civil contempt. And in most cases, the courts are very lenient when it comes to civil contempt. But criminal contempt is something very dangerous. When you're attributing motives to the judges, the judge gave this verdict because the judge is corrupt. The judge gave this verdict because he was paid money. The judge gave this verdict because of a particular caste ideology, because of a particular communal ideology. So you are scandalizing a judge. You are scandalizing a judgment. You are basically disreputing the Supreme Court. You are basically disreputing the seat of justice in this country. And the court orders are accepted by you and me because we see the courts as moral institutions in India. So if there is a speech, if there is a program, if there is a book, if there is any write-up which scandalizes the court, which brings the court into disrepute, willfully, deliberately you are scandalizing the court, that is contempt of court. But this contempt of court or criminal contempt of court is taken very seriously by the judiciary. And this criminal contempt of court can be filed in 3 ways. Which are these 3 ways? Number 1, either the Attorney General or the Solicitor General approaches the court. Attorney General, Solicitor General approaches the court and says, this person has committed contempt of court, please prosecute him. This is one way. Second way is suo motu. On its own, the court can take up a matter. On its own, the court can say, this person has committed contempt of court and we will punish him. Court on its own taking this matter onto itself. Suo motu. Third person. Who is this third person? Neither the Attorney General or the Solicitor General, nor the court itself, but a third person is now approaching the court that this particular gentleman has committed contempt of court, he should be punished. The law says, Criminal Contempt Act of 1971 says that you need in this case the permission of the Attorney General of India. Why permission? What is the reason? This can be asked in your prelims examination. So you might know that yes, in criminal contempt of court cases, we require the prior consent of the Attorney General for India. But what is the reason? What is the logic? The logic is to save the time of the court. Because Attorney General, he can now assess the court and say whether this is a fit case for contempt or not. If it's fit case, then you can proceed with the contempt proceedings. If it is not, then we will drop it. That means to save the time of the court, the consent of Attorney General is required before a criminal contempt can be filed against somebody. So statement number 1 is correct. In order to save the time of the court, no court shall initiate any proceedings of contempt after the expiry of a period of 1 year from the date on which the contempt is alleged to have been committed. This is also correct. Select the correct option from below. C, both 1 and 2 is the right answer. Now you might ask, sir, what about Prashant Bhushan? He is alleged to have given or said something contemptuous in an interview to a magazine in 2009, and today we are in 2021. It's been more than a decade. Why is this case continuing? Contempt of court case against Prashant Bhushan for this interview was registered in 2010. That means within 1 year of this offense to have been committed, alleged offense to have been committed. Now it might take 10 years, it might take 20 years, that doesn't matter. The question is asking, no court shall initiate any proceedings after the expiry of 1 year from the date on which the contempt is alleged to have been committed. This is right. But the initiation has taken place within a year. The final judgment may be given after 5 years or 10 years. Doesn't matter. Both these statements are correct. C is the right answer. Let's look at another question. Consider the following statements. Number 1, a high court shall have the jurisdiction to inquire into or try a contempt of itself only when the contempt is alleged to have been committed within its jurisdiction. A judge is not liable for contempt of his own court. Criminal Contempt Act 1971. It says it protects the seat of justice. Not the judge. That means contempt of court is an offense because we want to save the seat of justice. We want to save the institution of judiciary. That doesn't mean we are saving a judge. A judge is liable to be punished for contempt. And that is how Justice Karnan, he was sentenced to 6 months in prison by the Supreme Court because he wrote a letter to the Prime Minister Modi saying that there is corruption in the judiciary, there has to be an investigation into the corruption allegations against the judiciary. He was sentenced to contempt of court, 6 months in jail by the Supreme Court. So even a judge can be punished for contempt. So this statement is incorrect. Statement 1 is also incorrect. Statement 1 says High Court. Let's say Karnataka High Court. It can punish somebody who commits contempt only within Karnataka? No. There is somebody who is scandalizing Karnataka High Court while sitting in Delhi, while sitting in Manipur. No matter where you are staying, if you are committing the contempt of Karnataka High Court has the power to punish you for the contempt. That's why statement 1 is also incorrect. But the question is asking, look at this carefully. Which of the above statements is or are incorrect? Both these statements are incorrect. C is the right answer. And in India, Supreme Court can punish, has the power to punish people for contempt. High Court has the power to punish people for contempt. District courts, they cannot punish people for contempt. That doesn't mean you can commit contempt of a district court. High Court, the concerned High Court, for example, there is a district court in Karnataka. You are alleged to have committed contempt of the order of the district court. District court will not punish you. High Court of Karnataka will punish you for committing contempt of a district court. High Court has that power. District court in itself does not have this power. This is something that you will have to keep in mind. Let's look at another question, staying with the Attorney General for India. It's not Attorney General of India, it's Attorney General for India. That's important. He is part of the Union Executive. Yes, Union Executive consists of President, Vice President, Prime Minister, Council of Ministers, and Attorney General for India. That's true. His term of office is 3 years. However, the President can extend his term of office. Normally, his term is 3 years, but it's not mentioned in the Constitution. He holds office, and that's what we call doctrine of pleasure. He holds office as long as he enjoys the pleasure of the President of India, which basically means the pleasure of the Prime Minister. As long as Prime Minister is happy with the Attorney General, you can continue. Whenever there is a change in the regime, because primarily Attorney General's office is viewed as a political office. Whenever there is a change in the regime, Convention says Attorney General resigns, so that the next government can appoint someone that they trust as the next Attorney General for India. The term is not mentioned. Yes, the term is dependent upon the doctrine of the pledger. The term for Mr. K.K. Venugopal was 3 years. It was extended again, but that doesn't mean the term is fixed. The term of office is 3 years. However, the president can extend his term. That's not correct. 3, he can be appointed as a member of a parliamentary committee. In fact, Attorney General can be present in the parliament, can speak in the parliament, can be a member of a parliamentary committee, can speak in a parliamentary committee. The only thing that he does not have, right to vote, because he's not a member of the parliament. But he can be a member of a parliamentary committee. He is barred from private practice. No. He can practice privately as well. He is not barred from private practice, but whenever he takes up a criminal case, he has to take the permission from the central government, from the President of India. So the question is asking which of the following statements are correct. 1, 3, correct. C is the right answer. Which of the following is not part of the Union Cabinet? Prime Minister is part of the Union Cabinet. Cabinet ministers are part of the Union Cabinet. Ministers of state with independent charge, they are not part of the Union Cabinet, but they can be called to the meetings of the Cabinet, but we don't say that they are part of the Union Cabinet. They are distinct. Attorney General is part of the Union Executive, but he is not part of the Union Cabinet. So which of the following is not part of the Union Cabinet? 3 and 4, which means A is the right answer. Now let's look at another controversial topic, controversial in the sense which was in the news for a long time. Here we'll talk about Pegasus. Few details regarding this controversy, and then we will look at the questions. Pegasus is basically a spyware manufactured by an Israeli firm, NSO. And Pegasus basically is surveillance plus hacking. What is the difference between surveillance and hacking? For example, I enter a jewelry shop. You see that there is a CCTV camera to monitor whatever is going on so that we can catch the thief as well. That's called surveillance. Surveillance is basically monitoring. When we look at hacking, hacking is unauthorized access. What is this unauthorized access? Here's my phone. I got a message from you. Click on this link so that you can attend the live lecture 2 of Indian Polity BYJU'S IAS. I clicked on this link, and then the spyware was installed on my phone. And now you have got access to my phone, but you are not authorized to get this access. Unauthorized access you have been given, and through which what you can do? You can open my camera. You can turn on my microphone. You can make calls. You can read messages. You can send messages. You can do everything. This is hacking. So surveillance is monitoring. Hacking is unauthorized access. What makes Pegasus deadly is its zero-click exploit. What does that mean? Normally, how do you hack a system? How do you hack a computer? You send a message. You send a mail. I click on that mail. I click the message. Then the spyware is installed on my device, and you get the unauthorized access to my device. Pegasus is deadly because it is a zero-click exploit. Even if you do nothing, this spyware can be remotely installed on your device, and you can be put under surveillance. Your phone has been hacked. So this Israeli NSO which manufactures Pegasus is surveillance plus hacking. That's what makes Pegasus slightly deadly. News is, whether that's true or not, we don't know. But the news is that there are close to 300 individuals in India who have been subjected to this hacking using the Pegasus spyware. NSO of Israel says, we sell this Pegasus software only to vetted governments. That means we don't sell it to private individuals or private companies, we sell it only to the government so that these governments can tackle terrorism. So the allegation is that if there are 300 individuals in India, some political leaders, a political strategist, election commissioner who have been subject allegedly to Pegasus spyware, and if this Pegasus spyware is only sold to the vetted governments, does that mean the government of the day is spying, keeping these individuals under surveillance? That's why it is in controversy. We don't have to get into the controversial part, we have to get into the polity part of Pegasus spyware. Now, what is this issue here? Is surveillance legal in India? Yes. Is hacking legal in India? Absolutely no. What makes surveillance legal in India? There are two laws. Indian Telegraph Act of 1885. Number 2, Information Technology Act passed by the Parliament of India in the year 2000. This Indian Telegraph Act of 1885, listen to me carefully, can be very important for your exam. Indian Telegraph Act of 1885, it talks about surveillance through phone tapping. So your phone can be tapped. I'm calling somebody, the government can listen to what am I communicating. Surveillance is required. That means my conversations are being monitored by somebody, by the government. That doesn't mean you're hacking into my phone. Only my conversations are being monitored under Indian Telegraph Act 1885. Why? If it is for public emergency. If it is for the public security, if it is for public order, if it is for public emergency, you can be put under surveillance, which means your phone can be tapped under Indian Telegraph Act of 1885. So this act only and only deals with phone tapping, that too in cases of public emergency. When it comes to IT Act of 2000, it talks about surveillance of all electronic transaction, which means surveillance, not hacking. I am put under surveillance. That means my phone, my laptop, my computer, my desktop. I'm sending a mail. This mail can be intercepted. This mail can be decrypted because I am put under surveillance. And this Indian Information Technology Act 2000, it has an important section called Section 69, which authorizes the interception of all electronic transaction. It has another section, Section 69 capital A, which was also in the news. And this basically talks about blocking intermediary. For example, there is an app, there is a website which talks about some contempt, which talks about some content which is against the security of the nation, which is against the sovereignty and integrity of the nation, which is against friendly relations with foreign countries, which is against the defense of India. The central government may say, block this content. That's how more than 59 Chinese apps were blocked by the central government by invoking Section 69 capital A of Information Technology Act 2000. Surveillance is valid, legal. Hacking is illegal. Surveillance is valid through Indian Telegraph Act of 1885, which talks about phone tapping specifically. That too in the interest of public emergency, during public emergency. But when it comes to Information Technology Act of 2000, it talks about surveillance of all electronic transaction. And specifically, it talks about Section 69 capital A, which talks about blocking an intermediary. Blocking an intermediary if the content is against the sovereignty, integrity, security of the state, defense of India. In this Information Technology Act, there is Section 5 Clause 2, which makes Indian Information Technology Act 2000 slightly more broad, very vague in its application. It authorizes the government that you can put somebody on surveillance. Listen to me carefully. It authorizes the government that you can put somebody under surveillance if you want to investigate an offense. That means it's no wonder a terrorist or an alleged terrorist is put under surveillance. It's okay, because we have to ensure that we block or we prevent a disaster, prevent a terror strike. But there is an individual who is alleged to have committed an offense. Let's say, for example, I'm driving a car without a driving license, which means I have violated Motor Vehicles Act. To investigate into this offense, I can be put under surveillance. That means Section 5 Clause 2 of Information Technology Act is so vague that it gives enough power to the governments to put anybody on surveillance. But surveillance is valid, hacking is illegal. And surveillance is valid. How? Who can authorize surveillance? That can be a critical question for your prelims exam. Only the central government or the state government? Both. Central government can also authorize surveillance, state government can also authorize. But to prevent misuse, this power is given to a senior functionary, which means Union Home Ministry, Secretary of Union Home Ministry can order surveillance. Secretary of State Home Department can order surveillance. But whenever they issue an order, within few days, Cabinet Secretary at the central level, Chief Secretary at the state level, they have to review. That means there are some checks and balances in place. And when you put somebody under surveillance, you can authorize surveillance for 60 days, which can be extended to another 180 days. After that, you have to destroy the data. But this destruction of data is not universal. You can still save this data in unique circumstances. Long story short, who can authorize surveillance? At the central government, Secretary of the Home Ministry. At the state level, Secretary of the Home Department. Whenever they issue an order that I will be put under surveillance, within 5 to 7 days, Central Cabinet Secretary will review this decision, or State Chief Secretary will review this decision. Surveillance can be authorized for 60 days, extended to another 180 days. But after that, you have to destroy the data. But it's not necessary that the government will destroy all the data for all sets of people. For some people, it may still store the data, keep the data valid. That is very important for you to understand. Now let's look at the questions. Consider the following statements. The Indian Telegraph Act 1885 deals with interception of calls only, which is phone tapping. This is correct. Information Technology Act 2000 deals with interception of data and all forms of electronic communication. Correct? Absolutely yes. Hacking is not expressly prohibited under the Information Technology Act. This is wrong. Explicitly, hacking is prohibited under the IT Act. Hacking is not allowed. Surveillance is legal. Which of the above statements is or are correct? 1 and 2, A is the right answer. Let's look at another question. Which of the following statements is or are correct? Number 1, only the central government can issue an order for the interception, monitoring, or decryption of any information generated, transmitted, received, or stored in any computer resource. No, not only the central government, we have discussed. The state government too can order interception, monitoring of data. Number 2, the Information Technology Act allows interception, monitoring, and decryption of digital information if it helps in the investigation of an offense. This is correct. That's why I told you IT Act 2000, it is very vague. It gives a wide range of powers to the governments to put anyone under surveillance. Because under Section 5 Clause 2 of the IT Act, you can put somebody under surveillance if you want to investigate an offense. Which of the above statements is or are correct? A, one only is the right answer. Correct? Let's look at section 66 capital A, again in the news. Why? The year was 2015 in a very famous Shriya Singhal versus Union of India. The Supreme Court struck down section 66 capital A of Information Technology Act. This was part of Information Technology Act of 2000. It was added to Information Technology Act in the year 2008. But this was struck down by a two-judge bench of the Supreme Court in Shriya Singhal versus Union of India because it violates Article 19(1)(a) of the Constitution, which is freedom of speech and expression. Section 66A basically said if you use an electronic device, which can be a computer, which can be a smartphone, which can be a laptop, which can be a palm top, whatever it is, and if you are transmitting messages which are of menacing nature, if you are transmitting messages which you know are false, but your intention is to cause annoyance to the public or to somebody, you can be booked under section 66 capital A. 2015. The Supreme Court said this section 66A, it criminalizes free speech in this country and it is violative of Article 19(1)(a) of the Constitution. That is why section 66A is struck down, despite the fact that in 2015 this section was struck down by the court, by the top court, by the Supreme Court. Even today, people have been arrested under section 66 capital A. Matter went to the court, Supreme Court again this year. And Supreme Court said, we regret that even after 6 years since we have rendered section 66A as unconstitutional, people are still getting arrested under this section. That is how the court said more awareness needs to be created. The policemen should be engaged, should be told, communicated, informed that you don't have the power to arrest somebody under section 66 capital A. This was very recent, in the news, can be a potential question for your prelims examination. Let's look at something else. Tribunals Reforms Act 2021, it transfers the functions of which of the following appellate bodies to the high courts? Tribunals Reforms Act was passed in 2021, very recently. What does this act say? It is in response to Madras Bar Association. Statement number 1, Tribunals Reforms Act 2021 was enacted by the Indian Parliament in pursuant of the judgment of the court in Madras Bar Association versus Union of India. Is this statement correct? Yes. But this judgment, Madras Bar Association judgment given by the court, it talked about that there should be an independent Tribunals Commission. That means the government should set up an independent Tribunals Commission, and the role of this commission should be to monitor all tribunals in India. But this independent Tribunals Commission has not been constituted by the Parliament by passing this Tribunals Reforms Act 2021. So statement number 1, this law was passed according to Madras Bar Association verdict, yes. Madras Bar Association talked about that the state should set up independent Tribunals Commission to monitor the functioning of all the tribunals in this country, yes. But this independent Tribunals Commission has not been constituted by this act. Very important statement. Third, the Supreme Court had previously struck down few rules. Few rules were issued by the government. These were struck down by the court in Madras Bar Association case 2021. These rules basically said that the term of members of the tribunal should be 4 years. The rules also talked about that we should have tenure of 4 years for these members, and at the same time we should have chairperson and the members, where most of them will be appointed by the executive. But the Supreme Court said no, there should be a select committee. Judiciary should have more role in appointing members to the tribunal. And at the same time, don't keep 4 years as the tenure of a member, keep it 5 years. But this Tribunals Reforms Act 2021, it says that the term of members of the tribunals is 4 years. Despite the fact that the court had said don't keep it 4, keep it 5, the parliament said no, we will keep it 4 years. That's controversy number 1. Number 2, chairperson will hold office till he or she is 70. Members will hold office till he or she is 67 years. Can be important statement for your prelims examination. And at the same time, 50 age is the minimum age to be appointed as the member of a tribunal. That's also something which is mentioned in Tribunals Reforms Act 2021. So these are the things that you have to keep in mind. Long story short, Tribunals Reforms Act 2021, which the Parliament said, which in the Statement of Objects and Reasons the Parliament said that we are passing because we are giving effect to the Madras Bar Association verdict of the Honorable Supreme Court. But this verdict had said there should be independent tribunals commission, has not been created by the Parliament. The court said the term should be 5 years. The law said term should be 4 years. And judiciary is also criticizing that why do we keep 50 years as the minimum age for somebody to be appointed as the member of a tribunal. Keep this big picture in mind. Let's look at the question. This Tribunals Reforms Act also dissolves some of the appellate tribunals. The question is asking, Tribunals Reforms Act 2021 transfers the functions of which of the following appellate bodies to the high courts? Film Certification Appellate Tribunal, yes. Intellectual Property Appellate Tribunal, yes. Customs, Excise and Service Tax Appellate Tribunal, yes. Select the correct option from below, D. All these appellate tribunals dissolved and their role has now been given to that of a high court. For example, Film Certification Appellate Tribunal. I'm a filmmaker. I made a movie. Now I approach Central Board for Film Certification. I ask them, give me a certificate so that this film can be put for display, can be viewed by the public. If CBFC refuses to give me the certificate, then what do? I approach the review committee. If review committee also fails to provide me with the certificate, I approach the tribunal, Film Certification Appellate Tribunal. And only when this Film Certificate Appellate Tribunal refuses to give me the certificate, then I would approach the High Court. Filmmakers say that it was very easy to approach this appellate tribunal because we had to pay nominal fee and we would screen the film to the members of the tribunal and they would immediately give the order whether we will give you the certificate or we will not give you the certificate. Now, since this tribunal, appellate tribunal is dissolved by the Tribunals Reforms Act 2021, now we have to go to the High Court. We have to pay hefty fee to the lawyers and we don't know when this case will be heard, when judgment will be given by the Honorable Court. That means I as a filmmaker, I don't know when my movie is going to be released. That's why some people criticize this act saying stakeholders were not consulted before passing this law. Stakeholders are these filmmakers, you should have consulted them before dissolving this appellate tribunal. But others say it's very convenient. In any case, against the order of the tribunal, you had to approach the High Court. So there was this middle way. So there was this hiccup, appellate tribunal. We have dissolved it, now directly approach the High Court. Mumbai filmmaker had to approach tribunal in Delhi or in Mumbai, or somebody from Guwahati had to approach this tribunal. Now you can approach the Guwahati High Court. So it is very reasonable, very flexible, very convenient for a filmmaker. But whatever it is, these three tribunals have been dissolved and their powers, functions have been transferred to the concerned high courts. All these statements are correct. That is it for today. It's 9:30, 7:30 to 9:30 p.m. The remaining questions we will cover Saturday. So next Saturday, we will have another class, Polity-Based Current Affairs, Lecture 3. Then Sunday, Polity-Based Lecture, Current Affairs number 4. From tomorrow, we will have 4 lectures on economics-based current affairs. So stay with us. Join us again tomorrow, 7:30 p.m. But don't leave before liking this video. Drop in your favorable comments, because that is the only way of encouragement for us. And subscribe to our channel if you haven't yet. Thank you, and at the end again, Happy Teachers Day to me. And all those who are teachers watching this lecture, Happy Teachers Day to all of you. See you again next time. Till then, bye-bye. Good night.